whether you're going through a checkpoint or being pulled over, assuming it's a legal stop, they come to your window. The first thing the officer is looking for is any evidence, like whether they can smell the odor of alcohol or maybe marijuana or some other thing coming out of the car. They're going to look at your eyes. They're going to look at the way that you get your license and registration, the way that you handle that, if you're confused. And of course, people are nervous, their blood pressure's up. So, it makes it tougher to just be relaxed and do everything you need to do. Then they're going to ask whether you've been drinking if they smell alcohol, or they may ask anyway. If you say yes, if you deny it and they smell it, well, then they've already probably made up their mind. They're going to arrest you, and then they're just going to try and gather evidence. If they don't smell alcohol and you deny drinking, well, depending on how you look, they may not even ask you to get out of the car. But if they believe you might be impaired, they're going to ask you to get out of the car. They're going to ask you to do field sobriety tests. Now, most people don't realize that field sobriety tests are voluntary. Some law enforcement agencies will explain that properly, that it's voluntary. Some don't and claim that they did. All they're looking for, these tests, whether they're standardized or not, they're just looking for evidence to add to their case and their opinion already that you're impaired. And these tests can be difficult. For some people, very difficult. For other people, maybe not as bad. But the conditions, think about it. You're on the side of the road. It may not be even. There may be gravel. Like I've had cases where a lady is in high heels, but there's gravel on the road. It's uneven. So, she decides to stay in the heels, and she's trying to do these balancing tests, etc. So if you agree to them, they're gonna make you think you're doing them right. Oh, that's okay. Yeah, that's good. Let's do the next one. In reality, they're just writing down all the things that you did wrong so they can add evidence to your case. Then the last thing they do is the preliminary alcohol screening device test. It's a little handheld device. They don't have a printout. They'll usually do 2 tests, but they don't comply with the Title 17, and they are admissible, but not. I have never seen a case. Well, one case was a sheriff I represented who only had PAS tests. It's the only case I've ever seen where they took a case to trial based on just the PAS. It's voluntary. It's not a good idea in most cases to take that test. They tend to overreact to mouth alcohol. They're not necessarily going to know if you burped or if you just had alcohol in your system. What happens is it's in what the forensic experts call your gut. And so it's going to elevate the results that get into the deep lung air that measure your alcohol levels, and it will be overrepresented. That's what the forensic experts call it, being overrepresented. What I mean by that is that in reality, what's in your blood, what's affecting your brain, what's affecting your ability or your impairment levels at that time could be much lower than what this test will reveal. And they're less sophisticated. So I highly recommend that people do not take the PAS, that they respectfully decline. The danger is that sometimes some officers, not necessarily CHP, they're a little more sophisticated about DUI arrests, they're a little more trained, they have a lot more repetition, they're a lot better at it. But some, police or sheriffs, a little less up on it, will take a refusal to take a PAS as if that's a refusal. I've had a lot of these in different counties. And so they'll send a DMV and you request your hearing for your client, and then you get the evidence, and then you're looking at what's called the DS-367 form. It's a sworn affidavit that they fill out in order to send a DMV and say, okay, he was arrested at this time, this are the test results, etc. And they'll say it's a refusal, and then when you find out it's the PAS test where you're going to win, you got to go in and basically fight that. But it can be a problem because, refusals, whether you're under 21 or not, and people under 21 do have to take the PAS test, the preliminary alcohol screening. People on probation for DUI have to take the preliminary alcohol screening. But if you refuse, that's a 1-year suspension the first time, 2 years the second, 3 years the third time, no driving. So it's important to be careful how you react to the officer's request, that you're respectful, that you do as you're asked. But if you're educated and you know that you do not have to take field sobriety tests or the PAS test, respectfully declining and asking for blood or breath down at the jail is the best thing to do. After they arrest you, they take you down. It depends on the situation. Sometimes you end up at a substation if they want to test you quickly, or there's some other reason. But usually, like in Sacramento and a lot of other counties, they take you to the jail, the main jail. They process you through and have you take a test as soon as possible. If it's blood, in some counties you have to go to a hospital. Then there's an issue, like there is an issue with blood tests nowadays. In terms of needing a warrant, like if somebody's in an accident, they're in the hospital. There are ways to fight blood tests admissibility in a lot of cases, but that's the next thing. They need an evidentiary test. In some counties, San Joaquin, I believe, and some other ones, they have what's called an e-PAS, evidentiary version of the PAS device in the trunk. It's in a suitcase. That is an admissible version of a test, as if you've gone down to the big machine downtown, because it has a printout, it complies with Title 17, etc. So you have to be careful to know that in the counties where they have those, because you know, if you're refusing the PAS and then they say, oh, here's another one, and you don't understand that this is an evidentiary test, you could have a refusal if you're not clear. If they're not clear with you, and if you don't understand the difference. But most counties, they have the evidentiary tests down at a substation or at the jail, and then once you're booked, they sometimes hold you for a long time. I've heard that it has to do with the officers not wanting to walk people from the holding room to the front door unless they, you know, until they really have to. So you can be in there hours and hours and hours, overnight or whatever. When they release you, they give you a white sheet here in Sacramento, and most counties you get something that shows you when your court date is, and any other, you know, personal belongings you have. But otherwise, then you're released. Then you're on your own, and you're calling a cab or hoping that someone will come pick you up.